Students, here on the basis of my evaluation experience, I am telling you that the students they are losing more marks in solving the problems in the question papers. ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ ತಮಗೆಲ್ಲ ತಿಳಿದಂತೆ ಈ ಕಾನೂನು ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಯಲ್ಲಿ ತಮಗೆ ಒಂದು ಥಿಯರಿ ಕ್ವೆಶ್ಚನ್ಸ್ ಇರುತ್ತೆ, ಅದೇ ರೀತಿಯಲ್ಲಿ ಒಂದು ದೃಷ್ಟಾಂತ ಅಥವಾ ಸಮಸ್ಯೆಗಳನ್ನು ಸಹ ನೀಡಿರ್ತಾರೆ. ದಟ್ ಮೀನ್ಸ್ ಇಟ್ ಇಸ್ ವೆರಿ ಮಚ್ ಕಾಮನ್ ಟು ಟೆಸ್ಟ್ ಯುವರ್ ಲೀಗಲ್ ಅನಾಲಜಿ. The universities which will give theory type of questions as well as the illustration based problems to evaluate your logical reasoning, to know your the observation with regard to the law and how much you have know the concept with regard to the law. So here with regard to this method, students, I will tell you, you can score very good marks. That means here the majority of the students, because they don't know the steps, because of not knowing the steps, they are losing the marks. They are getting very less marks. So with regard to the illustration based problems, what the KSLU students, or any other law university students, what they are doing, they will with regard to the problem has been given in the examination, whether it may be law of torts or transfer of property act, Mohammedan law or constitutional law or any subject, any law subjects. What they will do, they will for that the illustration problem for the problem which has been given, they will write the essay type of answers. They will keep on discussing the things, and ultimately they will write the yes or no. And certain students, they will write simply yes or no. Here, you know how much marks has been kept for your the valuable decision. That means the idea, you know why the problems will be given. Here, when you become the advocates, the problem will come before you. That means how do you know the problems? How do you put forth your case before the court? How do you get the justice? And what is the issues will be there? So you should be in a position to know the issues. ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ನೀವು ವಕೀಲರಾದಾಗ ನಿಮ್ಮ ಮುಂದೆ ಒಂದು ವಿವಾದ ಬರ್ಬೋದು. ಅಂದ್ರೆ ವಿವಾದ ಇಲ್ಲದ್ರೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕೇಸ್ ಹಾಕೋದಕ್ಕೆ ಬರಲ್ಲ. ಅದರಲ್ಲಿ ಆ ವಿವಾದ ಅದರಲ್ಲಿ ವಿವಾದವನ್ನು ಬಂದಾಗ ಅದರಲ್ಲಿ ವಿವಾದಾಂಶವನ್ನು ನೋಡಬೇಕು. ಅಂದ್ರೆ ಅದರಲ್ಲಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗೆ ಯಾವ ಒಂದು ಸಮಸ್ಯೆ ಇದೆ, ಅದನ್ನು ಯಾವ ರೀತಿ ಬಗೆಹರಿಸಬೇಕು, ಕಾನೂನಿನ ಒಂದು ಮಹತ್ವ ಏನು, ಕ್ವಶನ್ ಆಫ್ ಲಾ ಏನಿದೆ, ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಏನಿದೆ. ಸೊ ಯು ಹ್ಯಾವ್ ಟು ಸಿ ವಾಟ್ ಈಸ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ, ವಾಟ್ ಈಸ್ ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್. So here with regard to those aspects, you should have certain what you call the legal knowledge, legal competence to solve those problems. Then only here why the universities will give this sort of problem is these are all some sort of the drill. These are all some sort of the exercises for you. That means how you are going to put forth the problem, how you are going to represent your case before the court of law. So that is the analogy behind giving the problems in the question paper. So I will tell you, students, you can score very good marks. You can score very good marks if you know the steps. That's why my effort in doing this sort of the videos with regard to the helping the students in a larger scale. But normally the students, they don't know the steps, how to solve the problems. ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳು ಈ ಸ್ಟೆಪ್ಸ್ ಅಂದ್ರೆ ಈ ಮಜಲುಗಳು ಅಂದ್ರೆ ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸುವಂತ ಒಂದು ಮಜಲುಗಳನ್ನ ತಿಳಿಯದೆ ಅವರು ಪರೀಕ್ಷೆಯಲ್ಲಿ ತುಂಬಾ ಕಡಿಮೆ ಅಂಕಗಳನ್ನು ತೆಗೆದುಕೊಳ್ತಾರೆ, ಕೆಲವು ಸಮಯದಲ್ಲಿ ಫೇಲ್ ಆಗ್ತಾರೆ. So today let us start our journey. Here, as I have done in the previous video also, there are several methods are there with regard to the problem solving. So here I am here with regard to the international pattern of internationally accepted methods of problem solving. the universally accepted the method is FIRAC and IRAC. I will take FIRAC. That is very convenient for you. It is very simple for you, so that you can follow this method for problem solving. ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ಇವಾಗ ಅಂತಾರಾಷ್ಟ್ರೀಯವಾಗಿ ಏನ್ ಭಾರತ ಇರ್ಬೋದು, ಯಾವುದೇ ಒಂದು ದೇಶ ಆಗಿರ್ಬೋದು, ಈ ರೀತಿಯ ಒಂದು ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸುವಂತಹ ಒಂದು ಪ್ರಯತ್ನದಲ್ಲಿ ಹಲವಾರು ವಿಧಾನಗಳನ್ನು ಅಳವಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಅದು FIRAC ಇದೆ, IRAC ಇದೆ, ಅಂದ್ರೆ ಸುಮಾರು ಒಂದು ವಿಧಾನಗಳಿದೆ. ನಾನು PQRLM ಅಂತ ನನ್ನದೇ ಆದ ಒಂದು ಮೆಥಡ್ ಅನ್ನು ಸಹ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. ಆದ್ರೆ ನನ್ನ ಮೆಥಡ್ ಅನ್ನ ಈಗ ನಿಮ್ಮ ಏನು ಇವಾಗ ಲಾ ಆಫ್ ಟಾರ್ಟ್ಸ್ ನೀವೇನು ಫಸ್ಟ್ ಸೆಮ್ ಸೆಕೆಂಡ್ ಸೆಮ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ, ಅದರಲ್ಲಿ ನೀವು ನಿಮ್ಮ ಮೇಲೆ ನಾನು ಇವಾಗ ಪ್ರಯೋಗ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅಂದ್ರೆ ನೀವು ಅದನ್ನು ಸಹ ನೀವು ಅಳವಡಿಸ್ಕೋಬಹುದು. ಆದ್ರೆ ಇದ್ಯಾವುದು ಅಂತಾರಾಷ್ಟ್ರೀಯವಾಗಿ ಅದನ್ನ ಸಾರ್ವತ್ರಿಕವಾಗಿ ಒಪ್ಪಿರುವಂತ ಒಂದು ವಿಧಾನವನ್ನ ನಾವು ಬಳಸೋಣ. ಅಂದ್ರೆ ಇದು ತುಂಬಾ ಸರಳವಾಗಿದೆ. ಅಂದ್ರೆ ನನ್ನ ಮೆಥಡ್ ತುಂಬಾ ಸರಳವಾಗಿದೆ. ಅದರಲ್ಲಿ ಹೆಚ್ಚಿನ ಒಂದು ವಿಷಯವನ್ನ ಬರಿಬೇಕು. ಇವಾಗ ನೀವು ನೋಡ್ಬೋದು 100 ಅಂಕಗಳಿಗೆ ಸಹ ಏನಾಗುತ್ತೆ, 100 ಅಂಕಗಳಿಗೆ ಸಹ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಇರುತ್ತೆ. ಮತ್ತೆ 80-20 ಸ್ಕೀಮ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ 80 ಅಂಕಗಳಿಗೂ ಸಹ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಇರುತ್ತದೆ. ಅಂದ್ರೆ ನಿಮ್ಗೆ 80 ಅಂಕಗಳಲ್ಲಿ 10 ಅಂಕಗಳು ಯಾವ್ದಕ್ಕೆ ಬರುತ್ತೆ, ಥಿಯರಿ ಕ್ವಶನ್ಸ್, 6 ಅಂಕಗಳು ಯಾವ್ದಕ್ಕೆ ಇರುತ್ತೆ, ಈ ಸಮಸ್ಯೆಗಳಿಗಿರುತ್ತೆ. ಅಂದ್ರೆ 100 ಅಂಕಗಳ ಒಂದು ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಯಲ್ಲಿ ಆ ಸಮಯದಲ್ಲಿ ಈ ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸುವುದಕ್ಕೆ ಹೆಚ್ಚಿನ ಅಂಕಗಳನ್ನು ಕೊಟ್ಟಿರ್ತಾರೆ. ಅದರಲ್ಲಿ 16 ಅಂಕಗಳನ್ನು ಕೊಟ್ಟಿರ್ತಾರೆ. ಅಂತ ಸಮಯದಲ್ಲಿ ಅದನ್ನ ಬಳಸ್ಕೋಬಹುದು. ಆದ್ರೆ ಈಗಿನ ನಿಮಗಿರುವ 6 ಅಂಕಗಳ 6 ಅಂಕಗಳನ್ನ ನಿಗದಿಪಡಿಸಿರುವಂತ ಒಂದು ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸಿರೋದಕ್ಕೆ ಇಷ್ಟು ಒಂದು ಮಜಿಲುಗಳನ್ನ ನೀವು ಬರೆದ್ರೆ ಸಾಕು. ಮೊದಲನೇದೇನಂದ್ರೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸಂಗತಿ, ಎರಡನೇದಂದ್ರೆ ಇಶ್ಯೂ ಅಂದ್ರೆ ವಿವಾದಾಂಶ, ಮೂರನೇದು ರೂಲ್ ಅಂದ್ರೆ ನಿಯಮ, ಅನಾಲಿಸಿಸ್ ಅಂದ್ರೆ ಅನ್ವಯಿಸುವಿಕೆ, ಲಾಸ್ಟ್ ಕನ್ಕ್ಲೂಷನ್ ಅಂದ್ರೆ ತೀರ್ಮಾನ. ಹಿಯರ್ you know what is meant by facts. That is the facts of the case. Facts means that is the facts of the case. And next one is issue means what is the issue between the plaintiff and defendant. What are all the exact dispute between the plaintiff and defendant. So that will be called as issue. And next one is rule. What is rule? What is the rule of law? What is the provision of law? What law will be attracted here? So that will be called as rule. So here what we have to do with regard to all these facts, issue, rule, we have to discuss this under the concept of analysis. So where we have to discuss all these things, analysis. We have to cover all these things. We have to discuss these things in the analysis section. Then we have to give the conclusion, students. But what normally students they will give, they will very much rush. They will be very much they are very much hurry in going to the decision, isn't it? So if you are very much hurry in going to a decision, it will not be good. So here that's why probably with regard to any movie, that means if you see the end, then what about the with regard to the entire story. So if you go to any movie, if ultimately some theme will be there, isn't it? So theme, the ultimate end of the movie will be there. But if the ultimate end of the movie comes first, whether you are going to see the movie, whether is there anything to know see the movie, and is there any justification in seeing the movie? So our fate will be like that. If we rush for conclusion, our fate will also be like this. So let us see certain problems with regard to the law of torts. Today we are going to discuss with regard to the problems with regard to the law of torts. Here the problem has been given in one of the question papers of KSLU. The problem is like this. X, a banker, refuses to honor customer's check having sufficient funds in his account belonging to the customer. So here what happened? X, a banker, refuses to honor the customer's check having sufficient funds in his account belonging to the customer. Customer wants or intends to file a suit, that is case, against the banker. Will he succeed? So here for your the conclusion for your the judgment. The problem has been given. How you are going to analyze it? So what is the liability of the banker? So these things, this aspect we have to discuss. Here we have to follow these rules: facts, issue, rule, analysis, and conclusion. First one is fact. Here, customer of a bank having sufficient funds in his account has issued a check in favor of a drawee. That means I have done. I have now simplified the facts. So what you have to do? You have to simplify the facts. Here, all the facts has been given in a passage like question. So you have to simplify the fact. Here our attempt is to simplify the facts. That is, customer of a bank having sufficient funds in his account has issued a check in favor of a drawee. So here a customer is having the sufficient funds in his bank account, and being satisfied that he is having the sufficient fund in his bank account, he has issued a check in favor of some person. We can call it as a drawee. Then the other aspect is, in spite of having sufficient funds, banker refuses to honor the check. In spite of having sufficient funds, banker refuses to honor the check. So here he is having the sufficient funds, but banker refuses to honor the check. Here what we have to see, here we have to discuss the facts. That means we have to highlight the facts. That's what we have to simplify the facts. Here there is no need of discussion with regard to the facts. At the first section, that is facts. ಅಂದ್ರೆ ಇವಾಗ ಸಂಗತಿಯಲ್ಲಿ ಏನ್ ಬರೀಬೇಕು, ನಾವು ಸರಳವಾಗಿ ಆ ಸಮಸ್ಯೆಯನ್ನ ಏನ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಅದನ್ನ ಬಿಡಿಸಿ ಅಂತ ಹೇಳಿದ್ರೆ ಇರುವಂತ ಸಮಸ್ಯೆಯನ್ನ ಒಂದು ಸರಳವಾಗಿ ಅರ್ಥ ಆಗೋ ರೀತಿಯಲ್ಲಿ ಅದನ್ನ ಬರೀಬೇಕು. ಎರಡನೇದು ಏನಂದ್ರೆ, we have to write what is the exact issue. One more thing I wanted to tell you, here with regard to facts, you are not supposed to write anything other than the facts which has been given in the problem. ಅಂದ್ರೆ ಅಲ್ಲಿ ಏನೋ ಒಂದು ಸಂಗತಿಯನ್ನ ಕೊಟ್ಟಿರ್ತಾರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಯಲ್ಲಿ, ಅದನ್ನೇ ಬರೀಬೇಕು. ಇಲ್ಲೇನೋ ಬ್ಯಾಂಕರು ಬೇರೆ ಯಾವ್ದೋ ಕಾರಣಗಳಿಂದ ರಿಫ್ಯೂಸ್ ಮಾಡಿದಾನೆ ಅಂತ ಬರೀಬಾರ್ದು. ಅಲ್ಲಿ ಏನೋ ಕ್ಲಿಯರ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಒಂದು ಇನ್ಸಫಿಷಿಯನ್ಸ್ ಆಫ್ ಅದು ಒಂದು ಯಾವ್ದೋ ಒಂದು ಅಕೌಂಟ್ ಅಲ್ಲಿ ಒಂದು ಸಾಕಷ್ಟು ಒಂದು ಮೊತ್ತ ಹಣ ಇದ್ರೂ ಸಹ ಬ್ಯಾಂಕರು ಒಂದು ನಿರಾಕರಣೆ ಮಾಡಿದಾನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಂದ್ರೆ ಅದೇ ವಿಷಯ. ಮತ್ತೆ ನಾವು ಇವಾಗ ನಮ್ಗೆ ಗೊತ್ತಿರೋ ಬೇರೆ ಎಲ್ಲ ವಿಷಯಗಳು ಗೊತ್ತಿರುತ್ತೆ. ಒಂದು 13 ರೀಸನ್ ಅಲ್ಲಿ ಒಂದು ಬ್ಯಾಂಕರ್ ಒಂದು ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾನೆ ಅನ್ನೋ ವಿಷಯ ನಮ್ಗೆ ಗೊತ್ತಿದೆ. ಆದ್ರೆ ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. ನಾವಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ ಮಾತ್ರ ನಾವು ಬರಿಬೇಕು. ಹಿಯರ್ ವಾಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಗಿವನ್ ಇನ್ ದಿ ಪ್ರಾಬ್ಲಮ್, ವಿ ಹ್ಯಾವ್ ಟು ರೈಟ್ ದಟ್ ಓನ್ಲಿ. ಬಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಅನಲೈಸ್ ವಿತ್ ದ ಹೆಲ್ಪ್ ಆಫ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಅಂಡ್ ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್. ಅಂದ್ರೆ ಕಾನೂನಿನ ಸಂಗತಿ ಮತ್ತೆ ಒಂದು ವಾಸ್ತವ ಸಂಗತಿ, ಅಂದ್ರೆ ಒಂದು ಕಾನೂನಿನ ಪ್ರಶ್ನೆ ಮತ್ತೆ ಒಂದು ವಾಸ್ತವದ ಪ್ರಶ್ನೆಯನ್ನ ನಾವು ಕಂಡುಹಿಡಿಬೇಕು. ಸೊ ಹಿಯರ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಡೂ, ವಿ ಹ್ಯಾವ್ ಟು ಫೈಂಡ್ ಔಟ್ ದ ಆನ್ಸರ್ ಇನ್ ದಿಸ್ ವೇ. Then we have to frame the issues. So with regard to issues, I keep on telling that here you can frame one issue or more than one issue. So that sort of the liberty is having. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ವಿವಾದಾಂಶ ಒಂದಾದ್ರೂ ಬರಿಬಹುದು ಅಥವಾ ಎರಡಾದ್ರೂ ಬರಿಬಹುದು. ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ನೀವೇನ್ ನೋಡ್ಕೋಬೇಕು, ನಿಮ್ಮ ಸಮಯದ ಒಂದು ಪರಿಧಿಯನ್ನ ನೋಡ್ಕೋಬೇಕು. ಯು ಹ್ಯಾವ್ ಟು ಸಿ ಯುವರ್ ಟೈಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್. ಅಂದ್ರೆ ನೀವು ಒಂದು ಪರೀಕ್ಷೆಯಲ್ಲಿ ನಿಮ್ಮ ಉತ್ತರವನ್ನು ಬರೆಯುತ್ತಾ ಇರುವಾಗ ನಿಮ್ಮ ಒಂದು ಕಾಲದ ಪರಿಧಿಯನ್ನ ನೋಡ್ಕೋಬೇಕು. ಸುಮ್ಮನೆ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬರ್ಕೊಂಡು ಹೋಗ್ಬಾರ್ದು. ಅದೇನು 6 ಅಂಕಗಳು ಕೊಟ್ಟಿದಾರ, 14 ಅಂಕಗಳು ಕೊಟ್ಟಿದಾರ, ಎಷ್ಟು ಟೈಮ್ ಇದೆ ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಬರೀಬೇಕು. ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ನಾನು ಸಿಂಪ್ಲಿಫೈ ಮಾಡಿ ಹಾಕಿದ್ದೀನಿ. Here we have to frame the issues, whether the banker is justified in refusing to honor a check even though customer of a bank having sufficient funds in his account. So in this way you can frame the issues. That means here whether the banker is justified in refusing to honor a check even though customer is having the sufficient funds in his account. So that is the main issue between the customer and the banker. And next issue is whether the legal rights of a customer is violated. Here what we have to see, whether the legal rights of a customer is violated even though he has not suffered a loss. Here the customer, he has not, strictly we can say he is not suffered, but whether his legal rights has been violated. So this issue we have to see. So where we have this aspect we have seen. So with regard to the we have written the facts and we have written the issue. Then we are going to see these are the problems in the relevant concepts. For example, you have seen this aspect in the torts. So which aspect you have seen this aspect in the general conditions of liability in tort. You have seen this aspect in the general conditions of liability in tort. Andre idanna apakrutyada swarupadalli nodidira. So I think you can remember there are two Latin maxims are there: injuria sine damnum and damnum sine injuria. Andre nashtavilada hani matte hani illada nashta. Injuria sine damnum again karitare nashtavilada hani. Innondu hani illada nashta, damnum sine injuria. Now here this problem is concerning only with regard to the injuria sine damno. Andre illi kottiranta ಒಂದು ಸಮಸ್ಯೆ ಯಾವುದಕ್ಕೆ ಅನ್ವಯಿಸುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಷ್ಟವಿಲ್ಲದ ಹಾನಿಗೆ ಅನ್ವಯಿಸುತ್ತೆ. So here here this aspect we can see in the Latin maxim injuria sine damnum, and which was elaborately discussed in the case law of Ashby versus White. So what we have to write in the provision of law, we have to write the relevant case law. As I told you, in provision of law, you have to write the rule of law and what are all the relevant factors will be applicable. So what are the relevant legal aspects? That means if it is the question of some other aspect contract, you have to write the section. And after that one, provision of law, if there is any case laws are there, so you have to write that case law, because the evaluator he will come to know how far you know the subject, how far you know the subject. So that will show your the law legal knowledge grasping power. So here this aspect has been discussed in the case law of Ashby versus White, and with regard to the same facts of the case we can see in the Marzetti versus Williams. So with regard to the instant case we can see same facts of the case in the Marzetti versus Williams. So here for this one very beautiful book you are having, that is Jane Pandey. Here most of these problems you can find in the Jane Pandey. Most of the what you call the issues, most of the problems which will come in the examination were discussed in the book of Jane Pandey, written with regard to the law of torts. So here the relevant case law is Marzetti versus Williams. Marzetti versus Williams. So this you have written with regard to the provision of law. What we have written? We have written the simplified facts. We have written the issues between the plaintiff and the defendant, that is the banker and the customer. We have written the what provision of law will be applicable with regard to this instant case. Andre ನಾವೇನ್ ಮಾಡಿ ನೋಡಿದ್ವಿ, ಈಗ ಸಂಗತಿಯನ್ನ ನೋಡಿದ್ವಿ, ಮತ್ತೆ ವಿವಾದಾಂಶ ಏನು ವಿವಾದಾಂಶ ಇದೆ, ಯಾರು ಒಬ್ಬ ಬ್ಯಾಂಕರ್ ಮತ್ತೆ ಒಬ್ಬ ಗ್ರಾಹಕರ ನಡುವೆ, ಮತ್ತೆ ನಾವೇನ್ ನೋಡಿದ್ವಿ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಅಂದ್ರೆ ಏನ್ ನಿಯಮ ಏನ್ ಅಳವಡಿಸಿದ್ದಾರೆ ಅನ್ನೋದನ್ನ ನಾವು ನೋಡಿದ್ವಿ. Provision of law can also be called as rule of law, that is rule. Next one is analysis, that is the analysis. So here what are all the things we have to write in the analysis means we have to write whatever the things which has been written in the facts, whatever the things which has been written in the issue, what are all the provision of law is applicable there. And we have to analyze that one. We have to do our analogy. We have to analyze the things on the basis of the issues, on the basis of the rule of law, provision of law, and on the facts and the issue, and on the basis of provision of law, we have to analyze those things in the section of analysis. Then only we can give the judgment or the conclusion. So in analysis, we have to write all those things. Here what I have written, with regard to instant case, the relevant issues for our consideration are issues. So issues, you know what are all the issues we have discussed. And with regard to then we have seen the same case law which has been decided in the Marzetti versus Williams. There also the plaintiff had sufficient funds in his account in the defendant bank. Here what we have to see, the person who is going to file the case can be called as the plaintiff, and whom he is going to file the case we will call that person as the defendant. So here the plaintiff, in this case Marzetti versus William, what happened? The plaintiff had sufficient fund in his account in the defendant's bank. In spite of this, the banker had refused to honor his check. It was held that the bank was liable to pay damages to the plaintiff, even though he had not suffered any loss. ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ, ಈ ವಸ್ತು ಏನು ಇವಾಗ ವಿವಾದಾಂಶ ಏನು ನಾವು ಸಂಗತಿಯನ್ನು ನೋಡ್ತೀವಿ, ಒಬ್ಬ ವ್ಯಕ್ತಿ ಒಂದು ಏನು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಒಂದು ಸಾಕಷ್ಟು ಹಣ ಇದ್ರೂ ಸಹ ಅವನ ಚೆಕ್ ಅನ್ನ ನಗದೀಕರಣ ಮಾಡೋದಕ್ಕೆ ಅವನು ಬೇರೆ ವ್ಯಕ್ತಿಗೆ ಕೊಟ್ಟಿರುವಂತ ಒಂದು ಚೆಕ್ ಅನ್ನ ನಗದೀಕರಣ ಮಾಡೋದಕ್ಕೆ ಆತ ಏನೋ ನಿರಾಕರಣೆ ಮಾಡ್ತಾರೆ ಬ್ಯಾಂಕರ್. ಅಂತ ಸಮಯದಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಅವನ ಒಂದು ಕಾನೂನುಬದ್ಧ ಹಕ್ಕುಗಳ ಉಲ್ಲಂಘನೆ ಆಗುತ್ತದೆ, ಆದ್ರೆ ಯಾವುದೇ ಒಂದು ಹಾನಿ ಆಗಲ್ಲ. ನೀವು ಇದನ್ನ ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡಿದ್ರೆ, ಇದೇ ಸೇಮ್ ಒಂದು ವಿಷಯವನ್ನ ನಾವು ಯಾವ್ದೋ ಮಾರ್ಜೆಟ್ಟಿ ವಿರುದ್ಧ ವಿಲಿಯಮ್ಸ್ ಅಲ್ಲಿ ನೋಡ್ತೀವಿ. ಆ ಪ್ರಕರಣದಲ್ಲೂ ಏನಂದ್ರೆ, ಒಬ್ಬ ವಾದಿ ತಾನು ಸಾಕಷ್ಟು ಹಣವನ್ನ ಒಂದು ಪ್ರತಿವಾದಿ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇಟ್ಟಿರ್ತಾನೆ, ಹಾಗಿದ್ರೂ ಸಹ ಅವನ ಚೆಕ್ ಅನ್ನ ನಗದೀಕರಣ ಮಾಡಲ್ಲ. ಅಂತ ಸಮಯದಲ್ಲಿ ನ್ಯಾಯಾಲಯ ಏನ್ ಮಾಡುತ್ತೆ, ಅಂತಹ ಅವನ ಕಾನೂನುಬದ್ಧ ಹಕ್ಕುಗಳ ಉಲ್ಲಂಘನೆ ಆಗಿರೋದ್ರಿಂದ ಅವನಿಗೆ ಯಾರಿಗೆ ಒಬ್ಬ ಗ್ರಾಹಕನಿಗೆ ನಷ್ಟವನ್ನ ತುಂಬಿಕೊಡಲು ಬ್ಯಾಂಕ್ಗೆ ಆದೇಶ ಮಾಡಲಾಗುತ್ತದೆ. ಇದೇ ಪ್ರಕರಣ ನಾವು ನೋಡಿದ್ವಿ ಯಾವ್ದ್ರಲ್ಲಿ, ಆಶ್ ಬಿ ವಿರುದ್ಧ ವೈಟ್ ಪ್ರಕರಣದಲ್ಲಿ. ಅದ್ರಲ್ಲಿ ಏನಂದ್ರೆ, ಒಬ್ಬ ವ್ಯಕ್ತಿ ಒಂದು ವೋಟರ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್, ಎ ಕ್ವಾಲಿಫೈಡ್ ವೋಟರ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಅಲೌಡ್ ಟು ಕಾಸ್ಟ್ ಹಿಸ್ ವೋಟ್. So the relevant the facts, that means here what we are discussing, a violation of legal right. There a qualified voter has not been allowed to cast his vote in the Ashby versus White. There also the case has been filed against the election officer, that is the booth officer, for refusing to allow a qualified voter to cast his vote. So there also there is a violation of legal right, even though there is no harm, there is no physical harm, but legal right has been violated. So on the basis of this one, these cases has to be decided. So we have to discuss those things in the analysis section. So here as there is a violation of legal right of a person without damage to the plaintiff, which is actionable per se. What we have to see, which is actionable per se, that with regard to the violation of the legal rights of a person. So whether it is caused any real harm or not, that means the suit can be filed, the damages can be claimed. So what should be our decision? So on the basis of the fact, issue, rule of law or provision of law analysis, we have to give our judgment. So here we have to write our judgment. But what the normally students they will do, they will write the judgment, they will write their conclusion, they will write their decision. So here you have to write your decision. So in view of the above analysis, the bank was liable to pay the damages to the customer even though he had suffered no loss. So this is with regard to the injuria sine damno. So in this way the questions may come. So here it may be here today we are going to discuss, we have discussed the injuria sine damno. In coming classes we can deal with regard to the problems with regard to the damnum sine injuria, like that. And I will take one more case law with regard to the next concept. So one more problem let us discuss. So that problem will come under the chapter of with regard to the general defenses or justification of tort. So here why I am concentrating with regard to problems means many students, majority of the students, they are losing the marks in this problem section. I will tell you students, it is very simply you can attempt. Only thing you have to do some little work. That means you can discuss among yourself. You are having the students group, you are having so many student groups are there. You can put up some problem, you can discuss among yourself with regard to this problem, which case law will come. So what are the principle has been adopted, only that is the beauty of solving these problems. Not only this law of torts, it with regard to any subject. So you are having so many groups here. Here you need not have to study entire textbook and entire reference books. So it is in your hand. It is your work. You have to do this work. You know the law. You have to solve this problem. It is very simple. So let us see the second problem. So here what has been given here? A schoolmaster caned a student. Schoolmaster has punished a student who had, contrary to the school regulations, been smoking in a street, discussed the liability of the schoolmaster. The schoolmaster caned a student who had, contrary to the school regulations, been smoking in a street, discussed the liability of the schoolmaster. So here some student was happily smoking in a street. So the schoolmaster, what he has done, he has observed the student was doing the smoking. So he has punished the student. So probably now caning has been now I don't think that teachers can be allowed to do the caning. That means ಏನಾದ್ರು ಬೆತ್ತದಲ್ಲಿ ಹೊಡಿಯೋದು. ನಾವೆಲ್ಲ ಚಿಕ್ಕವರಿರುವಾಗ ಹೈಸ್ಕೂಲಲ್ಲಿ ಇರುವಾಗೂ ಬೆತ್ತದಲ್ಲಿ ಹೊಡಿತಾ ಇದ್ರು. ಇವಾಗ ಏನಾದ್ರು ಹೊಡೆದ್ರೆ ಅದಕ್ಕೆ ಬೇರೆ ಯಾವುದೋ ಒಂದು ಜೂನಿಯರ್ ಜಸ್ಟಿಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಹಾಕ್ತಾರೆ. ಆದ್ರೆ ನಮ್ಮ ಲಾ ಆಫ್ ಟಾರ್ಟ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ಅನ್ನೋದನ್ನ ನೋಡೋಣ. ಸೊ ಹಿಯರ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು this problem, I have simplified the facts in this way. That is, there are school disciplinary rules which bars smoking by students. A student found smoking by the schoolmaster. The schoolmaster punished the student for smoking in street. Here, what happened? There may be school disciplinary rules or there may not be any school disciplinary rules. But here, what we can evidence from this problem is that a student found smoking in the school, student found smoking in the street. But every regulations, every rules of the school, what it will prohibit? It will prohibit the smoking by the students, isn't it? Because smoking is not good for the health, isn't it? So the schoolmaster punished the student for smoking in street. So these are all the facts of this problem. Here I have framed only one issue. It is enough. If you frame one issue, it is enough. You want to frame the more than one issue, then also you can do it. ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಏನಪ್ಪಾ ಒಂದು ಸಂಗತಿ ಅಂದ್ರೆ, ಒಬ್ಬ ಹುಡುಗ ಬೀದಿಯಲ್ಲಿ ಸಿಗರೇಟ್ ಸೇರ್ತಾ ಇರ್ತಾನೆ, ಅಂತದನ್ನ ನೋಡಿ ಒಬ್ಬ ಟೀಚರ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಅವನಿಗೆ ಬೆತ್ತದಿಂದ ಹೊಡಿತಾರೆ. ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಒಬ್ಬ ಸ್ಟೂಡೆಂಟ್ ಒಂದು ಬೀದಿಯಲ್ಲಿ ಸಿಗರೇಟ್ ಸೇರ್ತಾ ಇದ್ದ, ಅದನ್ನ ನೋಡಿ ಟೀಚರ್ ಹೊಡಿತಾರೆ. ಅಂದ್ರೆ ಸಾಮಾನ್ಯವಾಗಿ ಇವಾಗ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ, ಯಾವ ಸ್ಕೂಲಲ್ಲೂ ಯಾವಾಗಿದ್ರು ಯಾವಾಗ ತುಂಬಾ ಹಳೆ ಕಾಲದಿಂದನೂ ಅವರು ಏನು ಸೇದಂಗಿಲ್ಲ, ಸಿಗರೇಟು ಇದೆಲ್ಲ ಸ್ಕೂಲ್ ಪ್ರಿಮಿಸಸ್ ಅಲ್ಲಿ ಸೇದಂಗಿಲ್ಲ. ಆದ್ರೆ ಇಲ್ಲಿ ಏನಂದ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬೀದಿಯಲ್ಲಿ ಸೇರ್ತಾ ಇದ್ದ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಒಬ್ಬ ಶಿಕ್ಷಕನ ಬಾಧ್ಯನೇ ಅನ್ನೋದನ್ನ ನಾವು ಹೇಳ್ಬೇಕು. Here we have to discuss this problem with regard to some provision of law. So what is the provision of law? Let us see. Here issue is whether the schoolmaster is having authority to punish the student outside the school. Andre, what is the issue? What is the problem? That whether the schoolmaster is having the power to punish his student inside the what you call school premises. But what about his authority outside the school? What about the authority of a schoolmaster outside the school? So this is the issue in this case. So here with regard to this one, where we have discussed this concept means we have discussed this concept under the justification of tort. This concept has been discussed under the justification of tort. ಅಂದ್ರೆ ಇವಾಗ ಸಾಮಾನ್ಯವಾಗಿ ಇಲ್ಲಿ ವಿವಾದಾಂಶ ಏನಿದೆ ಅಂದ್ರೆ, ಒಬ್ಬ ಶಿಕ್ಷಕ ತನ್ನ ಸ್ಟೂಡೆಂಟ್ ತನ್ನ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಏನ್ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ, ಅವನು ತನ್ನ ಮುಂದೆ ಅಂದ್ರೆ ಒಂದು ಶಾಲಾ ಪರದಿಲಿದ್ದಾಗ ಅಂತ ಸಮಯದಲ್ಲಿ ಅಥವಾ ಅವ್ರೇನೋ ತಪ್ಪು ಮಾಡಿದ್ರೆ ಅಥವಾ ಏನಾದ್ರು ಸಿಗರೇಟ್ ಆದ್ರೂ ಏನಾದ್ರು ಕುಡಿಯೋದು ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಅಂತ ಸಮಯದಲ್ಲಿ ಅವರನ್ನ ಒಂದು ಶಿಕ್ಷೆ ಒಳಪಡಿಸಬಹುದು. ಆದ್ರೆ ಇಲ್ಲಿ ಸಮಸ್ಯೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆತ ಆಚೆ ಕುಡಿತಾನೆ, ಯಾರು ಹುಡುಗ ಒಂದು ಸಿಗರೇಟ್ ಅನ್ನ ಆಚೆ ಕುಡಿತಾನೆ. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ನಾವು ಏನ್ ನೋಡ್ಬೇಕಂದ್ರೆ, ಇದರಲ್ಲಿ ಒಬ್ಬ ಶಿಕ್ಷಕನ ಬಾಧ್ಯತೆ ಏನು, ಅವನ ಬೆತ್ತದಿಂದ ಹೊಡಿಬಹುದಾ, ಅಂದ್ರೆ ಅವನಿಗೆ ಏನಾದ್ರೂ ದಂಡನೆ ಸಿಗುತ್ತಾ, ಈ ತರ ಶಾಲಾ ಪ್ರಿಮಿಸಿಸ್ ಅಂದ್ರೆ ಶಾಲೆಯ ಹೊರಾಂಗಣದಲ್ಲಿ ಒಬ್ಬ ಹುಡುಗ ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಅವನು ಸೇರ್ತಾ ಇದ್ರೆ, ಸಿಗರೇಟ್ ಸೇರ್ತಾ ಇದ್ರೆ, ಅಂತ ಸಮಯದಲ್ಲಿ ಶಾಲಾ ಶಿಕ್ಷಕ ಅವನು ಬೆತ್ತದಿಂದ ಹೊಡೆದ್ರೆ ಅದಕ್ಕೆ ದಂಡನೆಗೆ ಗುರಿ ಆಗ್ತಾನ ಅನ್ನೋ ವಿಷಯವನ್ನ ನಾವು ನೋಡ್ಬೇಕು. ಇದನ್ನ ನಾವೆಲ್ಲಿ ನೋಡ್ತೀವಿ ಅಂದ್ರೆ ಅಪಕೃತ್ಯಕ್ಕೆ ಸಮರ್ಥನೆ ಒಂದು ಕಲ್ಪನೆಯಲ್ಲಿ ನೋಡ್ತೀವಿ. ವಿ ಹ್ಯಾವ್ ಸೀನ್ ದಿಸ್ ಆಸ್ಪೆಕ್ಟ್ ಅಂಡರ್ ದಿ ಕಾನ್ಸೆಪ್ಟ್ ಡೆಲ್ಟ್ ಅಂಡರ್ ದಿ justification of tort. You know what are all the various defenses will be available under the concept of justification of tort. Here general defenses will be there. So this will come under the concept of general defenses, where the defendant has got so many defenses. That is, he has got the defense under the act of God. that is vis major. He has got the defense under volenti non-fit injuria and swayam shati daivi krutya, and he has got the defense under inevitable accident, and he has got the defense under the private defense necessity, likewise parent and quasi-parental authority. Here we are looking this aspect under the aspect of parents and quasi-parental authority, where the defendant has got the defense. He has got the defense. He cannot be liable for punishment. So that aspect we can discuss under the parents and quasi-parental authority. ಅಂದ್ರೆ ಈ ಅಪಕೃತ್ಯಕ್ಕೆ ಸಮರ್ಥನೆಗೆ ಇರುವ ಒಂದು ಸಮರ್ಥನೆಯಲ್ಲಿ ನಾವು ಹಲವಾರು ವಿಷಯಗಳನ್ನು ನಾವು ಚರ್ಚೆ ಮಾಡ್ತೀವಿ. ಅದರಲ್ಲಿ ಸ್ವಯಂ ಕೃತ್ಯ, ಸ್ವಯಂ ಕ್ಷತಿ, ದೈವಿ ಕೃತ್ಯ, ಮತ್ತೆ ಈ ರೀತಿ ಹಲವಾರು ಒಂದು ವಿಷಯಗಳಲ್ಲಿ ನಾವು ಚರ್ಚೆ ಮಾಡ್ತೀವಿ. ಅದರಲ್ಲಿ ಒಬ್ಬ ಪ್ರತಿವಾದಿಗೆ ತನ್ನನ್ನ ಸಮರ್ಥನೆ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಹಲವಾರು ಒಂದು ಪ್ರತಿರಕ್ಷಣೆಗಳು ಇರುತ್ತದೆ. ಅದರಲ್ಲಿ ಇದು ಸಹ ಒಂದು. ಅದರಲ್ಲಿ ಏನಂದ್ರೆ ಪೈತೃಕ ಮತ್ತು ಪೈತಕ ಆಭಾಸ ಪ್ರಾಧಿಕಾರಗಳು ಅನ್ನೋ ವಿಷಯದಲ್ಲಿ ನಾವು ನೋಡಬಹುದು. ಪೈತೃಕ ಮತ್ತು ಪೈತಕ ಆಭಾಸ ಪ್ರಾಧಿಕಾರಗಳು ಅಂದ್ರೆ ಏನಂದ್ರೆ, ಒಬ್ಬ ಪೈತೃಕ ಅಂದ್ರೆ ಪೇರೆಂಟ್ ಮತ್ತೆ ಪೈತಕ ಅಂದ್ರೆ ಕ್ವಾಸಿ ಪೇರೆಂಟಲ್ ಅಥಾರಿಟಿ. ಅಂದ್ರೆ ಅದರಲ್ಲಿ ತಂದೆ ಮತ್ತೆ ತಂದೆಯ ಒಂದು ಸ್ಥಾನದಲ್ಲಿ ಇರುವಂತಹ ವ್ಯಕ್ತಿಗಳು. ತಂದೆ ಸ್ಥಾನದಲ್ಲಿ ಇರುವ ವ್ಯಕ್ತಿಗಳು ಅಂದ್ರೆ ಯಾರು? ಒಬ್ರು ಶಿಕ್ಷಕರು ಅಲ್ವಾ? ಅಂದ್ರೆ ಅವ್ರಿಗೂ ಗುರುಗಳಿಗೆ ಒಬ್ಬರು ದೇವರಿಗೆ ಸಮಾನ, ತಂದೆಗೆ ಸಮಾನ ಎಲ್ಲ ನಾವು ನೋಡ್ತೀವಿ ಅಲ್ವಾ? isn't it? So they are going to build our life, isn't it? So that we can see under this aspect of parents and quasi-parental authority, which can be discussed under the general defenses or justification of tort. So this concept, this relevant case already has been discussed in the case law of Rex versus Newfort. This case law, same case law has been discussed in the Rex versus Newfort. ಅಂದ್ರೆ ಇದೇ ಒಂದು ಪ್ರಕರಣವನ್ನ ಈ Rex versus Newfort ಪ್ರಕರಣದಲ್ಲಿ ನೋಡಲಾಗಿದೆ. One more thing I want to tell you, that with regard to almost all these problems, so whatever which you are going to get in the question paper, which will be majority of the questions will be given from the already decided case laws, which has been given by the decided case laws. So with regard to every subject, there will not be any much more. With regard to law of torts, you are hardly got the 20 to 25 cases, that is decided cases, and other case laws will be there, but some important case laws will be there. So we have to discuss that provision of law. ಅಂದ್ರೆ ನಾವು ಈ ರೂಲ್ ಆಫ್ ಲಾ ಅಥವಾ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ನಿಯಮಗಳಲ್ಲಿ ನಾವೇನ್ ಬರಿಬೇಕು? ಯಾವ ಕಾನೂನು ಅನ್ವಯ ಆಗುತ್ತೆ ಮತ್ತೆ ಯಾವ ನಿರ್ಧರಿತ ಪ್ರಕರಣಗಳು ಇರುತ್ತೆ ಅದರ ಬಗ್ಗೆ ನಾವು ಬರಿಬೇಕಾಗುತ್ತದೆ. So here these facts, issue, provision of law has to be discussed under this analysis section. So here what we have discussed, what is the decision has been given in the Rex versus Newfort. The court has held that there is a fiduciary relationship will exist, and the teacher has justified in doing this one. That means he stands in the position of the father, so that he can punish the student. He can punish the student. That has been discussed. So here in the analysis section, we have to discuss the relevant issues for our consideration in the incident case. That is whether the schoolmaster is having authority to punish the student outside the school. So here, what is the exact question of law? A question of fact is different. Question of law is there, whether the student is permitted to, whether the student can be punished for having smoke on the cigarette or any BD outside the school premises. Here, no doubt, the student has the student has smoked the cigarette or anything outside the school premises, where the teacher, strictly speaking, it doesn't have the authority. But here what happens, the position of the teacher is like his position is like a father. That means he probably in schools and colleges, even in the engineering colleges, the local guardian is your lecturers. The local guardian, the local father, they will be named, and the lecturers will act as the local guardians in the schools and the colleges. No doubt to your father and mother, they will be your guardians in the house. So here the fiduciary relationship will exist between the teacher and the student. So that's why the authority of the school teacher is like the authority of the father. The authority of the school teacher cannot be confined to school premises. So this is the wonderful judgment has been given in the Rex versus Newfort. ಅಂದ್ರೆ ರೆಕ್ಸ್ ವಿರುದ್ಧ ನ್ಯೂ ಫೋರ್ಟ್ ಪ್ರಕರಣದಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಒಬ್ಬ ಹುಡುಗ ಶಾಲಾ ಒಳಾಂಗಣ ಇಲ್ಲದೆ ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಒಂದು ಧೂಮಪಾನ ಮಾಡ್ತಾ ಇರ್ತಾನೆ. ಅದಕ್ಕೆ ಶಾಲೆ ಶಿಕ್ಷಕನು ಅವನಿಗೆ ಬೆತ್ತದಿನ ಹೊಡಿತಾನೆ. ನ್ಯಾಯಾಲಯ ಏನ್ ಮಾಡುತ್ತೆ, ಆ ಹುಡುಗನ ನಡತೆಯನ್ನ ತಿದ್ದುವುದಕ್ಕೆ ನೀಡಲಾದಂತಹ ಒಂದು ಶಿಕ್ಷೆ ಸರಿಯಾದ್ದು ಮತ್ತೆ ಅದು ಅಪಕೃತ್ಯ ಆಗೋದಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಬ್ಬ ಶಿಕ್ಷಕನ ಕೃತ್ಯವನ್ನು ಸಮರ್ಥನೆ ಮಾಡುತ್ತೆ. ಯಾವುದೇ ಒಂದು ಡ್ಯಾಮೇಜಸ್ ನಷ್ಟ ಪರಿಹಾರದಕ್ಕೆ ಆದೇಶ ಮಾಡೋದಿಲ್ಲ. ಸೊ ವಾಟ್ ಯು ಹ್ಯಾವ್ ಟು ಸಿ, ವಾಟ್ ಯು ಹ್ಯಾವ್ ಟು ರೈಟ್ ದ ಡಿಸಿಷನ್ ಹಿಯರ್. In view of the above analysis, the teacher is justified in his acts, so no liability exists here on the part of the teacher. So because of the rule which has been applied in the parents and quasi-parental authority, which has been justified under the tort. So under the concept of justification of tort or general defenses which can be defended by the defendant. So this is the thing. So these are all in this way we have to address the problem. That is it is very much simple. Only thing, if you follow the procedure, if you know what are the steps, then easily you can score good marks. But as far as possible, I wanted to cover almost all the problems since the 2011 our KSLU starts till today. So I want to cover all those problems, but I don't know how many problems I am going to cover. So it is your responsibility to solve the problems with regard to almost all the subjects. That's the beauty of the law student. You have to pursue your journey in that way. You have to apply your knowledge. You should not go for spoon feeding. So this is with regard to the problem solving with regard to the problem solving with regard to the problems which will come in the law of torts.